This is a statute that is not yet in effect. It'll be effective July 1, 2015. It's called the Massachusetts Sick Leave Act, and it's a Massachusetts law applying to Massachusetts employees. The regulations, draft regulations just came out. I'll talk about a little bit about that at the very end. What essentially the act does is it requires an employer to provide employees with sick leave, and certain situations it's paid or unpaid. So the first question is whether this act, which is effective July 1, applies only to employers with 11 or more employees. Which of you think that question is true? Okay, well, you would be wrong. It's false. So the significance of this act really depends upon your number of employees. So if you have employees that 11 or more, and that includes, you count your part-time and temporary employees, you have to provide up to 40 hours of paid sick time. So that's paid sick time if you're 11 or more employees. If your employees are less than 11, you have to still provide up to 40 hours of unpaid sick time. So this statute impacts all employers, regardless of size. Up to 40 hours of the unused sick time, paid or unpaid, can be carried over by the employee. So the way this sick time works is it accrues over time. So when the employee starts working, it starts to accrue. In this instance, since the statute doesn't come into effect until July 1, that's when the accrual will start with your current employees who have been there for at least 90 days. If you've been there for 90 days, on July 1, they start accruing. If you've been there for less than 90 days, then they have to work in the 90 days starting July 1. And the 90 days is important, is that the employee cannot take the leave until after the 90 days. So they've accrued at least some sick time. And the accrual is based on a number of hours, and it's based on 1 hour for every 30 hours that the employee works. If you're talking about exempt employees who aren't punching in and punching out, they're deemed to be working 40 hours a week. So that's how you would calculate their 30 hours, unless there's, you've got some arrangement or agreement with the employee, although they're exempt, they're working less than 40 hours, well then you'd use that number of hours. An employee may not use sick time for the physical or mental illness, injury, or medical condition of the employee's child, spouse, or parent of a spouse. So the question is, which of you think that this sick time is limited only to the employee caring for the employee's sickness or illness? Who thinks that this is true or false? Who thinks it's true? You'd be right, it's false. So a employee, this is much more narrow than the domestic violence statute that we talked about. It does only apply to the employee or the employee's dependent child. But you can take the leave for a normal sick visit, to take the child to the doctor or to yourself, to care for, again, the employee or self. And then, interestingly, there's a link back to the domestic violence statute, which is that you can take leave to address the psychological, physical, or legal effects of domestic violence. The difference between these two statutes is this is narrower in one respect and broader in another. It's more narrow in that you can only take the leave for domestic violence for the employee or the dependent child, whereas I mentioned in the other statute, it was a much broader category for which you could take the leave. It's broader in that it applies to employers who have less than 50 employees. If you remember the first statute I talked about, you had to have 50 or more employees. This virtually applies to every employer. It depends on whether it's paid or unpaid, whether you have more than 11 or more employees or less than 11. The next question is, may the employer require certification of the need for earned sick time from a healthcare provider only when the earned sick time period covers more than 24 consecutively scheduled work hours? So do you, can you require certification if the employee is just out one day? Who thinks this question is true? It is true. So essentially, the employee has to be out 3 consecutive work periods of up to 24 hours before you can require certification. And you cannot delay the taking of sick leave because you don't have the certification. And you may not require that certification describe in any detail the nature of the illness, or if it's for domestic violence, the details of the domestic violence. Essentially, you can get a medical note that's simply from a healthcare provider that simply excuses the employee that they had to take time off from work, and that's going to be sufficient for that employee to take the sick time. Again, what's the harm if you violate the statute? And the question here is, employees that violate are subject to criminal and civil proceedings brought by the Attorney General. Who thinks that's true? It is true. This has some very weighty problems. If you violate it, you can be found civilly or criminally liable by the Attorney General, as well as the employee also may bring a civil action against the employer, again, getting treble damages, attorney's fees, if the employee is successful. A couple other points that I'd like to make is with regard to notice to the employer, what type of notice has to be provided. The statute requires that good faith effort to provide notice in advance be made. That doesn't require it. I'm going to go through the regs in one quick second, but I believe the proposed regulations provides that the employee should at least give notice within 30 days after they take a leave that they didn't give pre-advance notice for. The employer can provide a more beneficial sick pay provision if it wants. And you can require the employee to use that leave before using the leave under the statute. But the leave that you provide has to accrue and be used for the same purposes. So it has to accrue on at least a 1 hour per 30 hours rate, and that they can use it for themselves or their dependent child. And you have to provide notice to employees. You have to post a notice in a conspicuous place, as well as give the employee written notice of the rights under the statute.
How does the statute dovetail with the company's pre-existing policy of use it or lose it sick time?
This can be carried over. At least 40 hours can be carried over year to year.
So from a keeping standpoint, you have to keep separate records?
Correct. Well, what you would do, and I don't know if your policy is structured so that it accrues on a more beneficial basis than this one. Because if it does, then you can substitute that, but they still get to carry that over. And if it's, again, this is in the regs, but if it's paid or unpaid, you could have an employer that's more than 11, so you start out with paid. And then you lay some people off and now you're under 11. If the employee carried some time over from the prior year that's paid, that remains paid, even though now the employee is accruing on an unpaid basis because you're under the 11. And then the employee can use the paid leave before the unpaid leave. Yes.
How does PTO work? So if we have 14 PTO days, how would that work?
Okay, again, it's either going to be in addition to, or it can be used in lieu of this. If it's developing on the same rate and for the same purposes, you can substitute the PTO. If not, you can then this would be applying with regard to the leave that the employee takes.
When you think about the cottage industry of lawsuits that have come up in connection with violation of overtime payments and failure to pay minimum wage, do you see the same potential explosion of cases for inadvertent violation of the sick time regulations?
Well, I think there will be a lot of potential litigation, whether it's inadvertent or intentional. But I think, yes, if people aren't familiar with this and aren't giving the requisite number of hours and don't allow carryover, you could definitely have a,
Do they get attorney's fees and treble damages for this?
they do. They do, if they're successful in prevail. It's under the same statute as the wage claim statute.
What if an employer is union and non-union workers? And the union workers do not get sick time right now under the collective bargaining agreement? Is it preempted?
That's an interesting question. The statute says all employees, applies to all employees. There isn't any distinguishment in the statute between union and non-union. So I would, depending on what side of the equation I'm on, you maybe have somebody arguing that because you've got and again, it depends. If you've got the collective bargaining agreement, it accrues at a rate similar or better than this, and you get the same at least 40 hours or more, then that's the substitute. So you wouldn't have, that would be the substitute instead of this. That would cover it. So you wouldn't have both. Yeah. Okay, go ahead.
So just to clarify, so, I want to get rid of the paperwork side of the accrual. Speed it up, I'll give them the 5 days. At the end of the calendar year, we run a calendar year. December 31st, they lose it all, but January 1st, they get 6 days to start. Am I legally covered since they're not accruing it, they can't use more than 40?
Well, so the problem, under the scenario you just painted, so they've got the 40 hours on December 31st. You want to wipe the books clean, and then the next day, they now have the 40 hours back. Well, I wouldn't structure it that way. I'd structure it as a carryover because that's what you don't want to get into confusion that you did. So I would structure it as a carryover. The other issue you run is, what if I have only 15 hours that I'm carrying over? So I carry over 15, and then you don't have to give me the additional to get me to 40. So I would have to accrue that. You'd be giving me better. Now you could do better and provide better, and then that would be the substitute for this.
So with the carryover, Larry, does that allow employees who haven't used, say in year one, didn't use any sick time, to stack the carryover amount onto year two accrual of sick time, so they end up, say, with 80 hours of sick time available in year two?
The most you can carry over is 40 hours, and the most you can take in a year is 40 hours. So you can't stack. So you start that year with 40, and you take 10 down. Now you're 30, and you start accruing to get back up to 40 again. Yes.
So does the employer have the option to buy them out at the end of the year as opposed to carrying it over?
No, in fact, the regs talk about that. One interesting thing is this applies to employees who according to the regs, primary workplace is in Massachusetts. And you can be working less than 50% of your time in Massachusetts, and it applies. So if you worked, you're a painter and you work in Rhode Island and New Hampshire, as long as you have a significant amount of work in Massachusetts, it would apply.
You said one about your comment about notification. You said it can happen 30 days after the absence?
Well, the statute requires a good faith effort to do it in advance. When I looked at the regs this morning, because they were just published, there was a reference to the fact that if the employee provides notice within 30 days, that would be considered appropriate.